overtime?
You know, this is a commonly asked question and a common misconception about overtime. Just to back up for 1 second, what is overtime? The Fair Labor Standards Act, which is the federal statute that governs who receives overtime and who does not, it sets out a guideline, and the basic premise is that for certain categories of employees, if they work over 40 hours in a given week, they're going to be paid time and a half for the hours over 40 that they work. So for example, if I make $10 an hour, I work a 45-hour week. If I'm an employee who needs to be paid overtime, if I work 45 hours, those 5 hours over 40, I'll be paid $15 an hour instead of 10. A very common misconception is that if you pay your employees on a salary basis, they do not have to be paid overtime, and that is not necessarily true. The question that needs to be asked is, what sort of work is this employee doing? And that's how you determine whether this employee is paid overtime or not paid overtime. The Fair Labor Standards Act has certain categories of employees who generally would never qualify for overtime. Professional employees, doctors, lawyers, executive employees, very highly compensated individuals, artistic employees such as musicians, artists, actors and actresses, certain technology sector employees. However, if you're a small employer and you've got employees who, for example, you're a startup, you've got somebody who by training and by passion is a web designer, but is actually spending a significant amount of his or her time running errands, answering the phones, ordering supplies, doing clerical work, you have to do a case-by-case job analysis. The question that you really need to look at, there's a base salary component. Is this person making at least $455 a week? By the way, the current state of the law looks like that number will go up. That's a very basic amount. But the second question, and this is really the question that is most frequently at issue, is what's this person actually doing? How much of their time is spent in a given week doing a task that does not qualify for overtime versus tasks that do qualify for overtime? This is a frequently asked question. It seems like the answer to everybody's problems. Just turn everybody into an independent contractor and don't worry about all of these employment laws. The independent contractor analysis really comes down to degree of control. And that's the question you need to ask yourself when you're determining whether your workers can truly qualify as independent contractors versus employees. It's what degree of control do you have over this person's work. There's a whole list of factors, and it's very fact-based. Where does the worker work? Are they working out of your office space? Are they working out of their own space or from home? Do they work for many companies, or are they working solely for you? How are you paying them? Are you paying them on a project basis, or are you paying them on some sort of weekly or hourly basis that begins to look like a salary? Are you controlling the method in which they're doing the work, or are you really just controlling the final product and saying, we're looking for you to design this one thing for us, go about it however you see fit? Are you supplying their supplies and specialized equipment, or are those things that they've invested in and they use on their own? There are many factors like this that are looked at. This is another question I get asked frequently. We're a small company. It seems like it's just worth the risk. We're just going to do this independent contractor thing, let the chips fall as they may, see what happens. Here are the risks. One, is you will owe all of your back taxes for all of these people if they're determined to be misclassified as independent contractors. 2, you can potentially owe back overtime and other wage issues. In Illinois, for example, you pay people for unused vacation time. Lots of other wage and hour sorts of questions can come into play, and there can be penalties for not having paid those wages. You also can get into trouble over not providing benefits for people who are determined to be employees who you were classifying as independent contractors. The real key, after you've done that factor analysis and you've looked at all of those degrees of control, and if you have a worker who truly is, an independent contractor, and appropriately you should have that sort of relationship, then the real key is your independent contractor agreement. That contract you want to make sure is carefully worded so that it doesn't include any of the traps of employment. You want that to be solidly worded to make clear what the relationship is that you have with